Good morning, everybody. In the previous video, we have discussed Article 175 and 176, which related to the power of the governor of that state to summon either the assembly or the council or both of them together and address them. Today, let us discuss Article 177, which says that each minister and advocate general of that state shall be entitled to participate in the proceedings of the legislatures and speak in them. The purpose and purport of this article is that we have seen under Article 164 that the Council of Ministers are collectively answerable to the legislatures. When they are answerable, naturally they have to attend and they have to speak. But of course, by virtue of this article, they shall not be entitled to vote in the proceedings of the legislatures because they are not members sometimes of the legislatures. Please consider for a while. The assembly is filled with their own party members or the party to which the council of ministers belong. What does it amount to saying? If we say that the ministers are answerable to the legislatures, it is as good as saying that the ministers are answerable to their political party. A meaningless statement. This is how Indian constitution was misunderstood, misused, misapplied, as a result of which there is political turmoil, political instability, political uncertainty, political horse trading in the form of buying and selling of elected members. Then you may ask me, what is the purpose and purport of this Article 177? I told you several times in the past, somebody forming government or becoming chief minister with majority in the assembly is contained in Article 130 of the Pakistan Constitution. But such a provision is not there under Indian Constitution. The ruler should not have majority in the legislatures. There should be separation of powers between legislatures and the executive. Legislatures are the houses which contain members of various political parties, and the executive is the governor of the state under Article 154. He is appointed by the President of India under warrant. I told you, President of India is the only elected executive in India under Article 55, read with Article 328. He is elected by the Electoral College consisting of all the MLAs in India and members of both houses of the Parliament without issuing a whip. That is a true secret ballot democratic election. Electing of chief minister with majority in the assembly or electing of the prime minister with majority in the Lok Sabha are not contained under Indian constitution, and that would not be the meaning of democracy. If you have majority and also rule the country, where is separation of powers? You are the legislative, you are the executive, you are everything. So you resort to retribution against your opponents, you will oppress your opposition parties, resort to rampant corruption and loot all state resources and allocate them in favor of your party men and others quid pro quo. And to gain this majority, you will distribute notes to votes, which again is another unethical practice in democracy. As a result, I tell you, in India, so far the democracy has not borne. Right from the beginning, from 1950, the president abdicated his constitutional authority in favor of the prime minister and remained confined to his Rashtrapati Bhavan. Having taken oath to preserve, protect and defend the Constitution of India and to devote himself for the service and well-being of the citizens of India under Article 60, is it the way to discharge such a lofty oath of office? For the president and governor, only for these two authorities, such oath of office is there under Article 60 and 159. All others, including Supreme Court judges, High Court judges, union ministers, state ministers, and members of parliaments and state legislatures, everybody take oaths to bear true allegiance to the Constitution and to uphold the sovereignty. Whereas the president does not take such oath. He takes oath to preserve it, protect it, defend it, and to dedicate his life for the service and well-being of the citizens of India. Having taken such a lofty oath of office, he cannot remain in the Rashtrapati Bhavan or the Raj Bhavans. A president of India, we are using lofty words for him. He is the state head, constitutional head, etc. He should not participate in politics. Then what should he do? What should he do then? Taking rest in Raj Bhavans and Rashtrapati Bhavans? It is not true. India is not parliamentary democracy. It is a presidential democracy like the US. President is an elected one. How can he get elected unless he knows the MLAs and MPs? He has to solicit votes from them. What is the relevance? What is his relevance to them? He should be involved in selecting them and seeing that they win the elections. He should train them up. And this president and governors address both houses of the parliament and here both houses of the state. And what is the purpose of addressing legislatures? And the governor has to address the assembly. Each session he has to address. Of course, through first constitutional amendment, it was changed as that he should address the assembly the first session of each year. He has power to prorogue or dissolve the house. By summoning both the houses under Article 176, what does he address? What is expected of him? To read the speeches written by his subordinates, the Council of Ministers, which is hypocritic. He often states, my government. What my government? You are not participating in the governmental affair. Really, governor is supposed to be the government. If driver does not mean a person driving, if a governor does not mean a person governing the state, what for is this English knowledge? Is he required to summon, assemble both legislatures and address that I will truly follow, I will truly abide by the advices of the Council of Ministers, I will not do anything without their advice, to prostrate before the assembly and the ministers? Is it the purpose of summoning them? Does anybody summon if he has no authority or power? It is the sovereign power given to him under the Constitution under Article 175 and 176 to summon legislatures. Who will summon? Who has authority, he will summon. And after summoning, is he required to submit to them that he will be obediently, without questioning, act as a dumb secretary to them? Such a funny thing is taking place in India, and the president and governors, who are the executive powers of the union and the states respectively, are not functioning in accordance with their oaths of office. So if you say that the ministers are collectively answerable to the assembly, it means that he is answerable to his own political party. Why to come to assembly? They can do it as well in their party office. But the true purport of this is that the ministers are appointed and removed by the governor under Article 164 at his pleasure. The President of India should form government at the union level under Article 74, 75, 77 and 78. His deputies, namely the governors, should form governments in the states under Article 163, 164, 166 and 167. So the governor and the minister should belong to one political party. If they do not have majority in the legislatures, that is the most ideal democracy. As obtaining in the United States of America, the American president does not command majority in the Congress there, and the governors do not command majority in the state legislatures. That is the definition of democracy, separation of powers between legislative and the executive. Whereas in India, the executive is made secretary to the legislative leader. As such, we do not have executive, any effective executive. As such, it cannot be democracy at all. Unfortunately, Honorable Supreme Court said in the case of state of Tamil Nadu versus Union of India that a governor is bound to assent or return the bills within 3 months, otherwise the bills are deemed assented to. It means you have nullified the executive in India. President, governor, their minister should belong to one political party, and there would be opposition parties in the legislatures. Proposing a bill is the stand of the opposition parties. Whether passing it or withholding it is the stand of the official party, which is in ruling through the president and the governors. And finally, it is the people who should judge who are right, whether the opposition party is right in proposing or passing a law, and whether the party in power is right in passing or withholding such bills. That is the beauty of democracy. Unfortunately, In S.R. Chaudhary versus State of Punjab, Honorable Supreme Court said that a person who is not member of the legislatures cannot act as minister for more than 6 months. He cannot be reappointed. I don't understand any rationale in that judgment. As I told you, the governor may not have sufficient members in the legislatures to be appointed as ministers. He can appoint up to 15% of the strength of the legislative assembly as ministers, but he may not be having so many members to appoint. That is the reason why it was provided that he can appoint anybody who is a non-member, but of course within 6 months he has to become member of any of the legislatures, either by election or by nomination by the governor again. Supposing such a vacancy is not there in the Legislative Council, and supposing there is no vacancy in the Legislative Assembly for midterm election, it is not fault of the minister. He is an experienced one. He is trusted by the governor. His purpose is to aid and advise the governor. Why the judiciary should interfere with this process? We called it as a public interest litigation in which the public are put to loss. Supposing it is a personal grievance under Article 32 or 226, how anybody is losing? As such, that cause of action was not worth agitating before any judicial forum. And moreover, judiciary is precluded from interfering with legislative proceedings under Article 122 and 212, and it is also prohibited from interfering with the functions of the executive. Executive cannot be summoned to courts, and civil and criminal cases cannot be foisted against them. It does not mean that their orders can be struck off by the judiciary. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. If you provide your cell phone number in the comment, I may even call you in person. I have started this web series to spread the true constitutional intent among the citizens of India. I am sure, and you are sure, there is a failure on the part of all vital systems in India, as a result of which we are seeing political instability, immorality, uncertainty, political strife, social and economic strife, poverty, terrorism, extremism, whatnot. Whoever have a source, they are fleeing this country for better life to other countries. At least this is the time to understand the constitution compiled by Dr. Ambedkar. My homage to him. Indian constitution is not only the biggest written constitution in the world, it is also one of the best constitution in the world. What is not there in Indian constitution is not there outside. It is for us to find out what is there in the constitution and to honor it. Thank you.